The Supreme Court recently declined to suspend key parts of the National Firearms Act of 1934, keeping strict registration rules for short-barreled rifles and suppressors in place, for now. This wasn't a final ruling, but it signals a drawn-out legal fight ahead, with the law's future hanging in the balance. The case challenges whether federal power can persist when the law's original tax justification has been removed. For gun owners, the status quo remains. Paperwork, background checks, and registration are still required. The legal battle now shifts to the lower courts, where the fate of federal gun regulation will be decided. The National Firearms Act was born in 1934, at a time when America was gripped by fear and uncertainty. The country was still reeling from the Great Depression, and headlines were dominated by notorious criminals like John Dillinger and Bonnie and Clyde. Their brazen use of automatic weapons and sawed-off shotguns shocked the public and put immense pressure on lawmakers to act. The act was a direct response to the violence and chaos of the gangster era, when shootouts and bank robberies seemed almost routine in some cities. Congress couldn't outright ban certain guns, so it imposed a steep $200 tax, nearly $5,000 today, on items like machine guns, short-barreled rifles, and suppressors. This was a clever workaround, using the power of taxation to discourage ownership without directly violating the Second Amendment. The law's real power came from its tax and registration requirements, which forced owners to register their weapons with the federal government. The Supreme Court later upheld these measures as a valid use of Congress's taxing authority, setting a precedent for future gun control laws. Over time, inflation eroded the tax's bite, making it less of a financial barrier. But the maze of paperwork, background checks, and federal oversight remained, creating a complex system that still affects gun owners today. What began as a workaround for limited federal power became a lasting regulatory regime, shaping the way firearms are controlled and tracked in the United States for generations. Today, many see the law as outdated, regulating items now common for sport and self-defense. Modern firearms technology and changing attitudes have made some of its provisions seem almost antiquated. This disconnect between the Act's origins and modern reality fuels today's legal challenges, as courts and lawmakers debate whether a law crafted for a different era still makes sense in our world. In July 2025, Congress made a historic move by eliminating the $200 tax on suppressors, short-barreled rifles, and similar items, components that had been tightly regulated for nearly a century under the National Firearms Act, or NFA. However, lawmakers left the rest of the NFA's framework untouched, including its strict registration and transfer requirements. This unexpected partial repeal created a constitutional paradox. The law's original foundation, the tax, was now gone. Yet the federal government continued to demand registration and oversight of these firearms and accessories. Almost immediately, gun rights organizations and legal activists sprang into action, filing lawsuits across the country. Their argument was simple but powerful. Without the tax, the federal government no longer has a constitutional basis to enforce the NFA's registration scheme. Lawsuits like Brown v. ATF and several others now directly challenge the NFA's very existence, seeking to overturn decades of federal gun regulation. Plaintiffs argue that Congress can't simply justify the law under a different constitutional power, such as the Commerce Clause, since that rationale was explicitly rejected by lawmakers and courts back in 1934 when the NFA was first enacted. What was intended as a concession to appease gun owners has instead become the spark for a sweeping legal assault on the entire structure of federal gun control, igniting passionate debate and nationwide protests. Now the courts face a pivotal question: can the NFA survive without its original tax anchor, or will this repeal unravel one of America's oldest gun laws? Gun rights advocates argue that the National Firearms Act, or NFA, is now a dead letter. Its original tax power has faded, and its registration regime is increasingly seen as unconstitutional in light of recent legal developments. They claim the law no longer serves its intended purpose, and is out of step with both the Constitution and the realities of modern firearm ownership. These advocates point to the Supreme Court's landmark Bruin decision, which demands that any gun laws must align with the nation's historical tradition, and specifically protect arms that are in common use by law-abiding citizens today. Plaintiffs argue that short-barreled rifles and suppressors are now widely owned for lawful purposes, such as sport shooting, hunting, and home defense. They insist these items don't fit the dangerous and unusual category that would justify strict regulation, but instead are part of everyday American life. Furthermore, They argue Congress can't now claim Commerce Clause authority to uphold the NFA, since that justification was explicitly rejected when the law was first passed in the 1930s. The case against the NFA is threefold, according to its critics. First, the tax justification that once supported the law is now gone. Second, the Second Amendment protects these items as arms in common use. And third, history blocks any attempt to create a new constitutional pretext for the law's existence. In short, they say the NFA is a relic of a bygone era, stripped of its original legal foundation and rationale, and fundamentally incompatible with the standards set by modern constitutional law and Supreme Court precedent. Now, the courts are tasked with weighing these arguments against nearly a century of legal precedent, and deciding whether the NFA can withstand this new wave of constitutional scrutiny. Supporters of the NFA argue it's still vital for public safety, even without the tax. The Federal Registry, they say, helps law enforcement track dangerous weapons and deters criminal misuse. They contend Congress can now justify the law under the Commerce Clause, given today's broader interpretation of federal power. Opponents' claims that SBRs and suppressors are protected by the Second Amendment are disputed. The government argues these are dangerous and unusual arms. Supporters also point out that Congress left the registration requirements intact, signaling intent to keep them. Dismantling the NFA, they warn, could create legal chaos and undermine decades of federal regulation. Ultimately, they urge the courts to defer to Congress and maintain the status quo until lawmakers act. The Supreme Court's recent action wasn't a final ruling, but a refusal to grant emergency relief. The justices want the lower courts to fully examine the arguments before they step in. For now, the NFA's registration rules remain in force, and gun owners must comply. The legal process will play out in district and appellate courts, likely taking years. The Supreme Court's denial signals caution, not endorsement of the law. Only after the lower court's rule could the case return to the High Court for a definitive answer. The fight over the NFA is far from over, it's just moving to the next stage. For gun owners, nothing changes yet. Registration, background checks, and long wait times remain. The real battle now shifts to the lower courts, where the NFA's future will be decided. Conflicting rulings could create a patchwork of laws, likely forcing the Supreme Court to intervene. Congress could also act, either repealing the NFA's registration requirements or re-establishing the law on new constitutional grounds. The Supreme Court's move is just the beginning. The law's fate now depends on both the courts and Congress. Gun owners and advocates must be patient as the legal and political process unfolds. The NFA faces its greatest existential threat in nearly a century, with its future more uncertain than ever.